So let's start way back, and I promise to fast forward. So in 1925, Congress enacts the Federal Arbitration Act. And the idea behind the statute, every reasonable legal historian will tell you, is that Congress wanted to promote arbitration between equally sophisticated businesses, so that then instead of going into litigation and having sort of acrimonious, time-consuming, expensive litigation lawsuits, businesses could continue to work together and have these arbitrations over disputes. And the arbitrators were often taken directly from these business areas so that they had some expertise, some background, and that would presumably make things run a little more smoothly, a little more quickly. And for 100 years, the idea was that arbitration was really, first of all, something that you entered into with full consent. So sophisticated, equal business entities would negotiate for contract for arbitration of certain disputes. Second, that we were using arbitration in sort of very niche areas like labor, complex commercial interactions that might require sort of the knowledge base of an arbitrator. And then it was not the sort of thing you would just sort of foist onto the unknowing person. And the Supreme Court upheld this view for many years. And one other side note, the idea was it's the Federal Arbitration Act, and so it would apply only in federal court, right? The idea being that we have a federal system and federal laws don't necessarily and always, especially when they're not constitutionally grounded, apply to state proceedings.